Welcome to our channel, the hub for tech enthusiasts and legal eagles. Today we're bringing to you a dialogue and exchange, a comprehensive discussion that will venture into the deep recesses of an intricate but highly relevant topic: intellectual property rights for AI systems in the EU. Whether you're an emerging AI developer, an established legal professional, an avid technology enthusiast, a seasoned intellectual property lawyer, a curious AI student, or simply someone who appreciates the beauty of the interplay between technology and law, our video today aims to be your definitive guide, your tangible platform for understanding every subtle nuance, every cryptic clause, and every complex layer of the world of AI and intellectual property. We shall traverse the labyrinth of legal terminology, demystify the most confounding aspects of AI rights, and decipher the cryptic language of law, providing an exclusive, comprehensive look into this dynamic field. So let's embark on this enlightening journey together. Artificial intelligence is not just a buzzword, it's a revolutionary force reshaping our world. For years, we've seen it transform industries, modernize healthcare, revolutionize manufacturing production lines, and personalize online shopping experiences. It's become an integral part of our daily lives, and its potential for future growth immense. With this innovation, however, comes a significant responsibility. When we talk about responsibility, one aspect that takes center stage is intellectual property rights, a crucial element that protects creators and innovators. The ability to own an idea, to patent an invention, or to copyright a unique creation is fundamental to promoting creative and innovative. In fact, the intersection of AI and IP rights presents a novel challenge in the world of law and technology. The European Union, recognized globally for its stringent and comprehensive laws and regulations, has a unique stance in this challenging landscape. They've developed an approach that manages to balance the protection of individual creators with the need to foster the growth of AI technology. This distinctive position has implications for creators and innovators, not just within Europe, but across the world. Let's delve into what this means for creators and innovators. In the EU, intellectual property rights are a web of regulations meticulously established to safeguard individuals who bring new and unique ideas to life. This elaborate system protects creators and innovators, fostering an environment where creativity and innovation can thrive without fear of plagiarism or theft. It ensures that the originator of an idea retains exclusive rights to that idea, benefiting from their hard work and genius. However, when it comes to the burgeoning field of artificial intelligence, the waters become increasingly muddied. Intellectual property rights in this rapidly advancing sector presents a unique challenge. How does one define the creator of an AI innovation? Is it the individual who programmed the AI, or the AI itself that performs functions and produces results beyond the scope of its initial programming? Moreover, who is to own the rights to a creation that sprang from the mind of a machine rather than a human? How do patents traditionally issued to human inventors work in this new landscape where machines capable of creating and innovating? These questions bring to light an entirely new aspect of intellectual property rights that needs immediate attention. As AI continues to evolve, the laws surrounding must be adapted to ensure fair practices and protect the rights of all involved parties. Who owns the rights to a machine's creation? How do patents work in the realm of AI? We'll answer all these questions and more. The challenge with AI and IP rights in the EU is the pace of technological advancement. In the expansive world of technology, the rapid development of artificial intelligence, often described as the fourth industrial revolution, poses a significant challenge to legal systems, both domestically and globally. This prevalence of AI is a testament to its potential, but it also raises a number of pertinent issues with respect to intellectual property rights. Intellectual property (IP) laws are principally designed to incentivize innovation and creativity. However, the advent of AI, which can itself create and invent, brings about unique challenges to these laws. There's a growing concern that IP regimes, as currently constituted, may not be adequate to tackle the issues raised by AI. Particularly, the corporate use of AI in creating products and services pushes the boundaries of existing laws and demands a reconsideration of traditional concepts of authorship and inventorship. With AI's potential to generate creative output, questions around ownership and attribution have become increasingly complex to tackle. Laws are indeed evolving. Their evolution, although gradual and constant, often seems to be several steps behind the rapid change in technology. While lawmakers are striving to keep pace with these changes, the challenge becomes even more daunting given the global scope of these technologies. As such, there's a lot of gray areas that we need to navigate carefully.
It's not just about protecting creations, but also about fostering innovation. This principle is at the core of what makes the European Union's approach unique and beneficial. Imagine a world where everyone's creative outputs are safeguarded, where the fruits of one's labor are not in danger of being stolen or misused. Now take that to another level and consider the progress that can be made when these protected creators are encouraged to innovate further. That's what the EU envisions, a landscape where protection does not stifle creativity, but instead fuels it. Their method serves a dual purpose. It safeguards original work and simultaneously encourages forward-thinking ideas. This balance is a tricky endeavor, but the EU strives to maintain it. It's a dance of protection and innovation, each step carefully calculated to ensure harmony. The EU's approach aims to balance these two crucial aspects. As we venture through this intricate and ever-evolving landscape, one thing becomes glaringly apparent. The European Union is at the forefront, bravely trailblazing the path for setting a groundbreaking precedent on how artificial intelligence and intellectual property rights can coexist harmoniously. This represents a fascinating crossroad where technology and law, two seemingly disparate fields, intersect in an interesting dance. This development is not just about patenting AI algorithms or protecting IP rights. No, it's much more than that. It delves into the realm of ethics, moral judgments, and the socioeconomic consequences of allowing or restricting access to such technology. It's about ensuring fairness, preventing monopolies, and fostering innovation across all sectors. But as we traverse this terrain, we're only skimming the surface. The complexity of the issue runs deep and spreads far. Across continents and cultures, every nation is grappling with these fundamental questions. What should be patented? Who owns AI-created content? Should we allow AI to copyright its own output? Let's turn the pages to the chapter where the EU is not just a participant, but the primary actor, setting standards, global policy. But important to note, this is only a snapshot of a much larger, evolving picture. We'll be delving into specifically intriguing cases and dissecting existing regulations. We'll examine the broader implications of these laws for the future, not just for the tech giants, but also for startups, innovators, and consumers alike. So strap in as we embark on this explorative journey, because this, my friends, is just the tip of the iceberg. Join us as we dive deeper into specific cases, regulations, and future implications of these laws. The journey promises to be as enlightening as it will be thrilling. As we conclude our journey through the intricate world of intellectual property rights for AI systems in the EU, it's clear that we've traversed a truly fascinating landscape. This topic delves into the depths of not just mundane laws and regulations, but it also unwraps the interwoven threads of complex legal, ethical, and societal issues. Our expedition has taken us through a maze of legislations across continents, through time and multiple interpretations. We've dived deep into the nebulous realm of patent rights, copyright laws, and trademark regulations, each a fundamental cornerstone of this colossal edifice known as intellectual property rights. Our dialogue has revolved around these facets, indicating the substantial role they play in shaping the trajectory of AI systems in the EU. It's evident that intellectual property rights is not a static domain. It's a dynamic, evolving entity, constantly adapting to the ever-changing landscape of technological innovation. It remains at the forefront of our discussions about AI, crafting the blueprint for future technologies and setting the pace for advancements in this field. We've also discovered that this subject, while seemingly daunting, can be broken down into comprehensible parts, each contributing towards the broader picture of IP rights. Through our journey, we've sought to demystify these complexities and illuminate the path for those who embark on this path in the future. Thank you for joining us on this enlightening exploration. Remember,